عامل ايه؟ Hello. Sir, shall we?
हाँ तो मैं कही चुका हूँ।
Sir, shall we start? Sir?
Yeah, I am ready.
Yes, sir. Yes. Just 1 minute. Saket, unmute yourself, please. Saket, switch off your camera. Ansh?
Yes, ma'am.
Yes.
Ma'am, am I audible?
Yes, clearly.
Okay. So, good afternoon to everyone. I, Ansh Verma, on behalf of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, welcomes you all for the today's webinar on the Employees Compensation Act 2010. I would now like to extend a warm and benevolent welcome at this virtual event to Advocate Dr. Shrikant Malegaonkar Sir, Advocate High Court and Labour Industrial Court, Pune, and Dr. Ujjwala Bindali Ma'am, Dean and in charge Principal, Bharati Vidyapeeth, deemed University, New Law College, Pune. Now, I would like to introduce our chief guest, Advocate Dr. Shrikant Malegaonkar Sir. Dr. Shrikant Malegaonkar Sir is a specialist in labor laws and industrial relation and is a practicing advocate at Pune Labour Industrial Courts and at the Bombay High Court for the past 28 years. His consultancy is by name Malegaonkar and Associates, as well as he has its own IT firm called Simzu. Dr. Malegaonkar Sir engages in litigation, consultation, and training in labor laws for Indian and multinational companies along with criminal law and commercial litigation as subsidiaries. He is associated with companies like Mercedes, Philips, Bridgestone, General Motors, Haier Appliances, Radisson Blu, Novotel, and many more. His consultancy, Malegaonkar and Associates, has successfully conducted more than 1,500 workshops for companies like Mercedes, Volkswagen, Telco, Fiat, Parley, Hyundai, etc. on employment laws. Now, I would like to invite Advocate Dr. Shrikant Malegaonkar Sir to address the virtual audience. Please, sir.
Okay. Thank you, Ansh. And we proceed. I'm going to talk with you, friends, on Employees Compensation Act. Now, it so happened that in the year 1857, we had the national uprising. After the national uprising, the Britishers took over, that is the Queen of England took over. And that is why we say that the Britishers are ruling over us since 150 years. Now, what happened earlier to that, the ruling as far as India was concerned, I mean, vis-a-vis the British, it was with the East India Company. But then in 1857, when there was a national uprising, the British Queen thought it fit that she would be taking over the East India Company and then ruling India. Now, how do you rule a country? In order to rule a small company, you require technocrats and lawyers and computer experts and this one and that one. But in order to rule a big country, first what is required was law itself. And there were no laws at that point, and that is why the British Queen appointed a person called Lord Macaulay, who was the then chairman of the Law Commission of India, and given a task of drafting different laws. 1860, as you understand, friends, the legal history, we had the Indian Penal Code, 1861, the Criminal Procedure Code, 1872, the Indian Contract Act. Things as far as labor movement really started in the year 1885, when we had the Bombay Mill Hands Association led by Narayan Meghaji Lokhande, who is rightly called as the father of the trade union movement. Then we come in the 19th century, we had a young Indians visiting India from South Africa. His name was Mohandas Karamchand Gandhi. They started the Gandhian era. Slowly and slowly things progressed, and ultimately we come to 1919, when we had the first major federation in India, which was called as the ITUC. ITUC is AITUC, means All India Trade Union Congress. Now in those days, there was only one Congress. This ABCD Congress is a later development. And after the INTUC had its federation, after the ITUC had its federation, the Congress also started its federation by name INTUC. INTUC, INTUC means Indian National Trade Union Congress. INTUC is an acronym. And after this, Indian leaders, say this is 1920, Indian leaders went to Soviet Russia, took lessons into trade unionism, and then started helping the Britishers to draft laws. And it was in the year 1923, the Workmen's Compensation Act was passed. This is the same Workmen's Compensation Act wherein the name has been changed a bit, and we call it the Employees Compensation Act, wherein they get compensation. And this is a part of my discussion today for in the forthcoming 1 hour. And what is really daunting is that I have to grasp the total Workmen's Compensation Act in 1 hour, but we will see as to how things are possible. For a moment, friends, let me share the screen with you. 1 second. Can everybody see the screen?
Yes, sir. Yes, sir.
Okay, just 1 second. If you don't see, and in between, I would be asking, in between, I would be just asking you a few questions, just to make myself aware of the fact that somebody is listening to me also. Okay.
Yes, sir.
Otherwise, it would be a monologue. I'm talking with the screen, and I don't know whether people are there listening to me or not. So in between, I would be asking you questions. Okay. Now you see, with the advent of the Indian Revolution, this Workmen's Compensation Act is a huge one. So allow me to skip off certain slides. Okay. If at all, you can skim through whatever is written in the slides, you can. Otherwise, I am here to explain as to what it is. Now you see, with the advent of the Indian Revolution, Industrial Revolution, labor force was exposed to the evils of the machine. Now you see, something happened in England. Cotton from India was sent to Manchester. Cloth was made. It was brought here. Transportation charges, and ultimately somewhere the government decided to have some factories and some mills in India itself. And all over India, this was an industrialization, and the Industrial Revolution exposed our labor force to the evils of the machine. Now you see, today we are having sophisticated machines. In those days, there were no sophisticated machines. And let me tell you, say if you go to Bombay, I'm sure everybody has been to Bombay. If you go to areas like Lal Bagh and Parel, you will even find today old mills are there, 125 years old. And people were working with yarn there. People were working with cotton. And inhaling the cotton, people had asphyxia and palpitation and uncomfortableness in the chest. Some died. And for your information, when their lungs were cut open, it was found that they were all cotton fibers in the lungs. Now, this is the evil of the machine. So it exposed our workers to the various risks of limbs and lives. Now, the technological advance and sophisticated of the machines exposed the workers to different sort of accidents. See, you are having lifts today. You are having consolidated hoists also. And then there are accidents there also. And with all of these things, it made the workman disabled. Now you see, you are the employer, somebody is working for you for his bread and butter. Is it not in the fitness of things that at least you cater to his safety? So you have to be conscious that he too is a human being. First is to treat him human, then have the safety standards and to ensure that he does not meet with an accident, though it appears to be a far cry. Because today also there are accidents, tomorrow. Can anybody envisage in India that from tomorrow, there will be no accidents? No, there are going to be accidents. So what we can do is to minimize the accidents, exhibit safety standards, counsel the workers, train the workers, and for which a law has been invented. Now, this law is in the year 1923 itself. Now, the above problem, the government was making a legislative enactment under the common law. Now, you see, under the common law, an employer is liable only in negligence. We had a very famous case in common law, that is Latham versus Quinn, or Quinn versus Latham, wherein it so happened, this was more in the context of a strike, wherein Mr. Latham was instigated by somebody to stop work, and he stopped work. So his employer filed a case against him, asking him damages, that you are working for me, there is a contract with me, I am paying you, and you at the behest of somebody else, how can you stop work? But well, this has happened. Today times have changed. Quinn versus Latham is an age-old story. Okay, I'll go to the next slide. Now you see, now the above problem was taken or understood by the government, making a regular legislative enactment. And under common law, an employer was liable only in negligence. And in England, the employer's liability was limited only to a certain defenses. Steps were taken by the British Parliament to enact the Workmen's Compensation Act 1923 for the simple reason that in 1923, it is yet British India. Everybody knows that we became independent in 1947. Now you see, the question of granting compensation, one second, action of a factory, question of granting compensation to the workmen for accidents gained momentum in 1884. 1885, friends, remember the Congress Party was born, that is in 1885, Allen O. Hume. It is earlier to that one day, that I am working in your factory, if something happens to me, who is to pay the compensation? This concept is even today. Just understand that in a road rage, one party is browbeaten by the other. And then if there is a collision between a cycle and a scooter, the cyclist, he asks some compensation from the scooterist. And this goes on and on. The bigger the vehicle, the larger the compensation you have to pay. We are not on that. In factories, some compensation is to be paid. The factories and the mining inspectors felt the existing Fatal Accidents Act in 1855 did not cater to all of these things, and that is why the state considered the issue seriously when a committee consisting of members of the Legislative Assembly and the workers' representative ultimately culminated together that yes, there must be some sort of a legislative enactment. Medical and insurance experts were also taken into. Just one second. Why is the? One second. Okay. Now you see, this is the formation of the act. I'm not going to take you through each and every word of the slide which you see, but then ultimately I come down to one thing, that it was necessitated that due to the rise in cost of living in the recent past and to incorporate the recommendations of the Indian Labour Conference, amount of compensation was to be given to those who met with the accidents. So by now we understand that I am a worker, I am working in a factory, ultimately my hand is cut, and then if my hand is cut, somebody has to give me the compensation. As law students, you are already aware that there are different types of liabilities. One is a limited liability. Limited liability is, which we have it in company law, that the liability of the shareholders is fixed by the number of shares he holds is not what the liability which we are discussing here. Then we are having a joint and several liability which basically applies to partnerships, which is also not the case here. You are aware that in partnerships, it's a joint and several liability. And moreover, basing on the case state of Bihar versus Damodar Prasad, making it very simple, that today the surety also will equally be jointly and severally responsible to pay the debt of the principal borrower. We are not on that also. Third is a wrong of absolute liability, that is the Bhopal gas tragedy. You are absolutely liable. It reminds me of a case that there was a zoo in England and somebody went to visit the zoo and he was taking some leaves and feeding the camel. The camel bit his finger. When the camel bit his finger, he filed a case against the zoo authorities that a ferocious animal like the camel is let loose in the zoo. And then the courts had to opine as to whether a camel is a ferocious animal or not. And the answer is that if at all it is, then you have to pay me absolute compensation because this is a wrong of absolute liability, which is not the topic which we are discussing here. Then what are we discussing? The total edifice, substratum, foundation of the Workmen Compensation Act is a liability in law which is called as a vicarious liability. Your vicarious, whatever is the pronunciation, you can call it sweet. And as far as vicarious liability is concerned, somebody is responsible for the act which is done by somebody. So I am the employer, I have started a factory, somebody works for me, and then he is to pay the workman compensation. Okay, so he is to be paid the workman compensation, and we have to pay him the workman compensation. The question is that how much, when, where, how, all of these interrogatories would be rising. Another question is, say I am Ratan Tata, I have a company called Telco, and I am sitting in Jamshedpur. I have a company in Pune which is called Telco, and there is a worker working on the machine, and that worker puts his hand in the machine, his hand is cut. And if his hand is cut, now you see Ratan Tata did not take his hand and put in the machine, so why should he pay compensation? But there is a fiction of law, there is a phenomenon of law, there is a concept of law which will make the employer responsible, though he has himself not done anything. And this is what is exactly the basis and the edifice of the Workmen Compensation Act, that you are vicariously liable. Now you see, this takes us to the objectives and the importance of the act, that is the Workmen Compensation Act. The object of the Workmen Compensation Act is to provide compensation to the workmen in the event of happening of certain contingencies. Now, what is basically, if you see any act, any legislation, it should have a purpose. Otherwise, why is the government, why is the legislature enacted the act itself? So here it is to provide compensation to the workmen in the event of happening of certain contingencies. Now, the Royal Commission on Labour had observed that to provide compensation to a workman who is incapacitated by an injury from an accident, the compensation is the only benefit which flows. And then they emphasized on furthering work on prevention of accidents. Now it's twofold. On the one hand, you prevent accidents, but in spite of that, something happens. Let's take the case of a driver. The driver is driving a vehicle. Can you guarantee that there will be no accident? I'm saying, can there be a guarantee? And the answer is nobody can guarantee. And if at all there is an accident, so there must be some compensation. And as far as workmen are concerned, greater freedom from anxiety and in rendering the industry workable, this was all very necessary. Okay. Now, ultimately, we come to the Royal Commission's observation. They said that the growing complexity of industry, increasing use of machinery and consequent danger to the workmen, whom they should be protected. Ultimately, it squares down to one thing, that tomorrow there are going to be more machines and heavy machines and different machines and hazardous machines. What about the protection? And if at all workers are to be protected from the hardships arising from the accidents, there must be a lot to cater to it. And that is why the Workmen Compensation Act was passed, which aimed at to workmen in the event of an accident and to ensure that the workman is not on the streets due to non-earning capacity. Now, friends, first and foremost, you have to think in these cases with the heart and not with the brain. There is a workman. He is having a family of 4 to feed, his wife and children, and tomorrow an accident happens and he is incapacitated. How will they have 2 square meals a day? While I'm going through the slides, I will also share some personal experiences with you. I remember those were the days that there was a client I had and I had just started practice. Now today, to visit a client at his place is not possible. In those days, I told you I was just a new entrant in practice. And I had a client, I wish I could remember his name. What happened is, his son came to me and said that, okay, sir, we have to see my father. I had no much work, so I agreed to him and we went into some hospital. And his father was on the bed. And lying on the bed, he spoke with me. Whatever notes I wanted, I took. And while leaving, I just asked him a question as to how many days are you on bed? I thought he would say 2 days, 3 days, 7 days max. He said, I am on the bed in this condition for 27 years. And I got a shock of my life because he was lying still and what could be movable in his body? The neck. And only the neck was movable and this person was lying. He fell from a hoist. Hoist is a girdle which moves to and fro on a shop floor. From there he fell on his spine and injured his spine. Total body was paralyzed. And what about the compensation? The employers in India, you know, they are very ruthless. They never opted out for a proper compensation. And ultimately we had nothing to do but to go and file a case for which I had visited him. I go further, friends. So protection to the workman is very important. Royal Commission said the attempt is, it is necessary because it cannot be arbitrary in operation. Advantages gain at what should outweigh the disadvantages. First and foremost, what happened in those days that there was no uniformity. For the same injury, he gets 10 rupees, I get 25,000, he gets 1 lakh. And then they said, what nonsense is going on? There must be an equal protection for everybody for the same accident. It goes without saying that for the same accident, there should be the same compensation. Now, the Act affords protection to a workman from an injury caused by an accident in the course of and out of the course of employment. And the employer is liable under Section 3 of the Employee Compensation Act. Now, what does this say? What is the personal liability or the employer's liability? A personal injury is caused to a workman by an accident. The employer shall be liable. Now, here the word, friends, is used is shall. And under interpretation of statutes, you are all aware that the word shall never includes shall not, whereas the word may includes may not. I may meet you in the garden tomorrow means I may not meet you in the garden tomorrow. But you shall come to the court tomorrow, means you must come to the court tomorrow. So first and foremost, you have to see the wording of that. So if a personal, I will request all of you all to switch mute the mic.
Yes, sir.
Okay.
Shivangi.
If a personal injury is caused to a workman by an accident, employer shall be liable to pay the compensation as per the provisions. Where an injury does not result in the total partial disablement of the workman for a period of more than 3 days, then normally nothing is liable to be paid. Now, the third thing is any injury not resulting in death caused by an accident, which is directly attributable to the workman who is under the influence of drinks and drugs. Again, nothing is to be paid. I'm going to explain everything in detail. And ultimately, the willful disobedience to a rule expressly framed for the safety of the workman. Now, let me take it one by one. First and foremost is that when is compensation to be payable? And the compensation to be payable is when the accident arises in the course of and out of the course of employment. Now, how do you say that the workman the accident arose in the course of and out of the course of employment? There are certain tests. I mean, there are tests which have been put up by Lord Acton and Lord Sumner and many of the law lords there. And one of the best tests which I have liked is, was it a part of the workman's duty to hazard of which he is suffering? I'll make it simple. I mean, why is he suffering? Because he did something. Because he did something, there is some injury. So was it a part of his job to hazard, or that occupational hazard which might result into an injury? I'll again make it simple. Say, for example, there are certain occupational hazards. I am a lawyer, so I have to go to courts. Then sometimes there is a rush hour. Sometimes clients are happy with me. Sometimes they are not happy. Sometimes I win the case. Sometimes I lose the case. They are all my occupational hazards. Had I been a rickshawala, one day there is a tire puncture, one day there is no petrol, one day the policeman stops me. So these are all occupational hazards. If I am a doctor, there is a late night call, then I am rushed. I have to be called at the dead of the night. Somebody gives me a phone call, Doctor Saab, abhi kya abhi aa jao. So I have to rush. These are all occupational hazards. Question is, was it a part of his duty to hazard? And if the answer is yes, then the accident arose in the course of and out of the course of employment. Likewise, tests are there. Let me tell you, friends, that only on these two words, that is in the course of and out of the course of employment, at least not less than 5,000 books have been written. And even today, the question is a bit dicey as to whether it arose in the course of and out of the course of employment. Now, an injury will come to the partial disablement later, and when it is payable and when it is not payable, for which I will have to tell you certain things. Say, there are many accidents which arose very recently. Let me tell you, very recently in the sense 15 days ago. There is a sugar factory which is my client. As you understand, the sugar is cut. It's cut into pieces. Then it goes in a cylinder sort of a thing. Now in that cylinder, it's a huge cylinder. A person can stand in it. And in that cylinder, there is an axle. And on the axle are different knives. They are very sharp. And what happened is, two workmen, the sugar cane was there. It's cut into small pieces. Then it goes further. Then it's created or converted into juice, squeezed up. You know this process. And two workmen were having lunch. One finished his lunch earlier. So what happened is, when he finished his lunch earlier, he went into that cylinder because something was stuck in the axle. Now that second workman, who had not finished his lunch, he also finished his lunch, but 10 minutes later. Now he is not knowing that his friend is inside the cylinder already. And he pressed that green button. The knife started rotating inside. It was only discovered when the chemist came running after, say, 10 minutes as to why is the juice, that is the sugarcane juice, red. Then they stopped the full machinery. Then they hunted out for this person. Where is he? He was not to be found. To be frank, friends, he was chopped into pieces. And once this is there in a factory, immediately you have to report a fatal accident to the factory's inspector. Okay. But for which, again, now the question is whether it arose in the course of or out of the course of employment. Or some months earlier, there was a construction work which was going on. And for the construction work, you know, there is a mixer they have. In the mixer, they put sand and cement and water, and then they pass on the parcel. And then a slab is built and filled in, and all those things you must have seen. Now, one worker, to remove something in that mixer, he went inside the mixer. Again, the same thing happened. Nobody knew as he was inside, and somebody pressed a button. The mixer started moving, and that poor fellow again chopped into pieces. So for all of these are industrial hazards or accidents for which something ought to be payable. Okay, we will come, just go a bit further. Now, workmen, any safety guard for the device provided for the safety guard. Okay, I can again come back to this slide. Now, there are certain incidences when the compensation is not payable. Compensation is payable, not payable when the workman is under the influence of drinks or drugs. It so happens that now I used to represent the bus corporation, and there the driver, he has a bottle of some sort of a liquor, and he is already intoxicated. Then he drives the bus, and there are 50 passengers behind. Loses control, and you have read it in the newspapers that the bus went tumbling in the valley. So many people were killed. Now, if the driver dies in the process, it's a different thing. But if he doesn't die, he runs away in the jungle. After 3 days, comes and surrenders to the police, and he says, "I swear on God that I have never touched liquor in my life." Now, how do you prove it? It becomes a very difficult and a daunting task to prove that he was drunk while on duty. And in spite of a departmental inquiry being held and he being removed from service, he gets a reinstatement from the labor court, say after 2 to 3 years. I don't know how far I am true and how far I am false, but then I am told by some of my friends that 60 to 70% of the drivers who are working in all these corporations are drivers who even today drink. And they have been acquitted by the courts, or they have not been punished by the courts in, say, labor jurisdictions. And then sometimes you have to be a traveler there. What will happen to you, only God knows. But you see, if at all somebody is caught and his negligence is directly attributable to the influence of drinks or drugs, and means how is it so simple? How do you prove that a person is drunk? For which you have to first is you have to apprehend that person. Then you have to take him to a police station. Then you have to take a blood and urine sample and then send it to the laboratory. And if at all there is alcohol in the blood and urine sample, then only he is drunk. Otherwise, he is not drunk. Now, this test of Evidence Act is a very high test. And that is why, very unfortunate, but many of the people go scot-free. Then under the influence of drinks or drugs. Now, this comes up to a question as to what is the drug itself. Under the Narcotics Act, there is a schedule. And in the schedule, the list of drugs are there. That these are all drugs. That is understandable. Means what? Afim is a drug and ganja is a drug and what's that? LSD is a drug and brown sugar is a drug. And there are many variations. I mean, I'm not an expert in narcotics, but there are many variations of that. Say a weed, that is also a sort of a drug. And then I'm told that people, and even college students for that instance, some of them, I'll not paint everybody with the same brush, but then some of them are also under the influence of drugs. They get addicted to it. Then they go to any extreme, even to the extent of killing somebody and all of those. But the question is, if at all a driver or any worker is under the influence of drugs, what is his fate? Whether compensation would be payable? Now, friends, let me tell you. Hello. I'll request everybody stop the video as well as the audio. So that will help me understand.
Okay. I'm sorry, sir. I'm so sorry. Students are requested to kindly mute yourself.
Okay. So what I was saying is that what is a drug? It starts from there. Now the question is, can tea be called as a drug? It's not in the narcotic schedule, but tea is a drug. If you have a cup of tea, some people feel fresh. Some people feel, say, you are feeling sleepy and you are dozing in your slumbers, and then somebody tells you, why don't you have a cup of tea or a cup of coffee? Coffee contains caffeine. Tea also contains the freshness which you get, which after having tea, there is some chemical in tea. And then I'm not very sure, but though being a science graduate, there is some oxidation of something which makes you feel that. Point for our discussion is whether tea can be called as a drug, whether coffee can be called as a drug. Technically, yes, but not in the narcotic family. And this will differ from case to case. Okay. I remember when I was in Nigeria, let me share an experience with you. And I had to go from one city to another. And then the highways there are very beautiful because Nigeria once upon a time was the chairman of OPEC. OPEC is Organization of Petroleum Exporting Countries. So oil was very rich. So roads are very rich. Beautiful roads are there. And my driver was taking me somewhere. and at some place, I found that he put something in his mouth. Now you see in India also amongst friends, we do it that if somebody is eating something, say groundnuts, and we ask him and we or rather we tell him that, oh, you are eating alone, come on, give me also something. In friendship, this is allowed. In friendship, this is allowed. So I told him, what are you eating? So come on, give it to me. On a friendly note. And he was to give me what he was eating. What he was eating was a cola fruit. Coca-Cola, everybody knows. So from that cola family, there is a fruit, which is called as a cola fruit. And he gave it to me on my palm and then stopped me. He said, sir, have you eaten this earlier? I said, no, I'm seeing it for the first time. He said, sir, then don't eat it because you will get intoxicated. It's like, putting a pinch of tobacco in your mouth. If you have never eaten tobacco, that also is going to have an effect on you. And then you will feel drowsy, possibly you will feel sleepy, you might go to sleep because they are all drugs. They might not be drugs of the drug family, that is the narcotic family, but then certainly there are drugs. Now, friends, there are so many workers who under the influence of tobacco work. There are some workers, I am told, they cannot work unless he has a bottle or half a bottle of that country liquor. Say, for example, if you go to Sassoon Hospital, there are people who conduct postmortems. And the atmosphere is, it's like a dungeon. All over dead bodies, post-mortem. And then the way they conduct a post-mortem on a dead body is really, I cannot describe also. They crack the skull and it's a very dangerous sort of a thing to happen. And the question is, a human is doing it. So they drink. The question is not that. Our question is, if at all an accident takes place in the course of and out of the course of employment, and it is proved that this person was under the influence of drinks and drugs, then compensation will not be payable. Now, next is willful disobedience to a rule expressly framed. Now, this is an entry which you find in the model standing orders. What are model standing orders? In simple words, they are the rules which are applicable to a factory. And this is a misconduct, willful disobedience. Say our engineers are sent to Germany, thousands and crores of rupees are wasted. Then they bring a machine from there, crores of rupees. And with the machine comes a manual that how you have to operate the machine. You have to operate it in that fashion only. Otherwise, a machine is a machine. It's dangerous. And what happens is that people operate machines in the way they like. They open the machines. There is an overhauling of the machine. They disturb the default settings. Default settings are there. Whenever you buy a mobile phone, the company gives you some default settings. It is you who fidget with it and then put your screensaver, and then some other things are there, somebody's photograph. That is your contribution. Otherwise, the default setting is already available in your mobile phone. Likewise, in a machine, some default settings are there. And with that default setting, people fidget. Say they disturb the RPM. RPM means what? Rotations per minute. Now the machine is to function at say 100 rotations per minute. In order to increase production, some employers, they make it 200 rotations per minute so that the production will be fast, workers remain the same, and production is doubled. And what about the risk? Who is to face the risk? The worker faces the risk. Say for till 2000 pieces, nothing happened, but 2001 something happens and the worker is dead. Who dies? Worker dies. What about the employer? Are we not going to make him responsible within the four corners of the law? And for which the Employers' Compensation Act is there. Willful disobedience to a rule expressly framed. German engineers, Korean engineers, Japanese engineers, Chinese engineers, they come to India, work on the shop floor with the workers and tell them that this machine is to be operated in this fashion only. You cannot operate it in another way. And if at all some worker disregards the rules and operates the machine in that manner which he is not supposed to do, or rather he is prohibited to do, and meets with an accident, the employer will say, I am not going to pay compensation, which is allowed. when a compensation is not payable. When he is to pay compensation, that also we saw. When he is not to pay compensation, that also we saw. And then how do you find the compensation? Allow me to be a bit fast. Now you see there are certain schedules as far as the Workmen Compensation Act is concerned. Some schedules are there to the act. The thing is, what we do is that we see the schedule, whether it is a disablement or whether it is fatal. If it is a disablement, every part of the human body is almost, I mean, to the maximum extent. Say, for example, my thumb has 2 phalanges. So if the first phalange is broken, how much is the compensation? If 2 phalanges are broken, how much is the compensation? Okay. So if my wrist is broken, how much is the compensation? That is in the schedule. Then a formula is there, a workable formula. And the accident shall be deemed to be arising in the course of employment. Say my shoulder is broken. So how much should be the compensation? Now this will depend on how much wages this person is drawing. And today they have fixed it at a minimum of 15,000 rupees per month. So all calculations will be made on 15,000 rupees per month and so and so. So there are formulae, but I'm going to tell you something further. In case of fatal accidents, how do you calculate the compensation? Fatal accidents, again, there is a schedule. If you see the schedule, it starts somewhere at 18. That is the age. Why it cannot start at 17? Because a person, as per the Indian Majority Act, becomes a major at the age of 18. You cannot employ somebody who is less than 18 years of age. Just one second. You cannot employ a person who is somebody who is less than 18 years of age. So at the age of 18, he joins duty. When he is 19, he meets with an accident and he dies. Now, how is it to be calculated? Compensation, for which you have to go to the schedule. For age 18, there is a corresponding factor. Say, for example, factor is 420, that is 420. Then the age is 19. Then you will see that the factor becomes 419. Age becomes 20, factor becomes 418. Age becomes 21, factor becomes 417. So in simple words, if you see, as the age goes on increasing, the factor value goes on decreasing. In simple words, age is inversely proportional to factor. So in simple words, if somebody dies at the age of 58, the compensation will be less. And somebody dies at the age of 18, the compensation will be the highest, that is more. But this is with respect to fatal accidents. Then you have to see 50% of the wages multiplied by the factor, and then that becomes a huge compensation. For your information, friends, let me also tell you that there is another law, a social security legislation, which is called as the Employees State Insurance, that is ESI Act. ESI means for the workman, you pay an insurance to the insurance corporation, and then they will take care of the accidents, etc. But insurance corporation will take care only of workmen whose wages are less than 21,000 rupees. There are workmen today who draw 30,000 rupees also. And if he meets with an accident under ESI, he is an exempted employee. But what I'm trying to emphasize upon you is ESI and workmen compensation do not apply at the same time. They apply, only one will apply. Both cannot apply at the same instance, either workmen compensation or ESI. So if ESI is applicable, this is not applicable. And here we are considering only Workmen Compensation Act. So if this is applicable as per the formula which is laid down in the Workmen Compensation Act, you will have to make a workable formula. And then how much are the wages? 50% of the wages multiplied by the factor, that will be his compensation. Again, this goes without saying that the accident should arise in the course of and outside the course of employment. Same is with the disease. Say there is a welder, and the welder, you have seen welders working in workshops, small workshops, and then there are some electrodes which they rub against that metal, and then there are sparks. Sometimes they are not given goggles to wear, safety goggles. Sometimes that shield is not there. And if you see those sparks with your dead eyes, bare eyes, and if you see them with your bare eyes, it might damage the eye, impair the retina. Some people have become blind. Point of our discussion is whether the disease arose in the course of and outside of the course of employment. And again, I will refer to what Lord Sumner said. Lord Sumner said, was it his duty to hazard? And if the answer is yes, then the accident arose in the course of and out of the course of employment. Okay, so we go a bit further. Now, allow me to skip a few slides. Okay, now agreement between the workman and the employer. Now what happens is, many a times unscrupulous employers, they have an agreement with the worker. Compensation, they calculate, compensation is 5 lakhs of rupees. Employers say, we will have an agreement with you, 50,000. You also sign, you got the money, I will also sign. Question is, if an agreement is between an employer and his workman for the payment of compensation in respect of the injury, what are the provisions? Now you have to first understand what is an accident itself. If you knew it would happen, it cannot be called as an accident. Accident is some unexpected event. Suppose you are a driver and then you have removed the brakes and you have started running the vehicle in full speed. Logical consequences, you have to know as to what could be the logical consequence. Then it cannot be called as an accident. Accident is some untoward happening as per the law lexicon. Okay. Then accident is some unexpected event happening without design, though there may be negligence on the part of the workman. Now this is important. And then Manikchowk Mills case. Now it includes what? Collisions, tripping over floor obstacles, falls off roof. Then the less obvious ones causing injury, exposure to a draught causing chill, exertion. The other day I remember somebody caught, there's a company in which was that called? I mean, ice below say 50 degrees. It's frozen to such an extent that it is dry ice below 50 degrees. And the engineer picked it up with a forceps. And somebody, one of the visitors said, come on, let me put it on my palm. He said, no, it is like putting burning charcoal on your palm. I mean, that ice will come down from below, possibly injuring your bones also. So that is not to be touched. And all these cause accident, shocks, neurasthenia. Common factor is some concrete happening at a definite point of time. And all of these have to be seen in a proper spirit. Now, these are observations of Lord Atkin. What is in the course of and out of the course of employment? Harris versus Association of Portland Cement. Once you found the work which you do is within the employment, the question of negligence, great or small, is irrelevant. And no amount of negligence in doing an employment job, if a workman is doing an act within the scope of his employment, is negligent in any degree, and the risk injured by a risk occurred by that of doing it, he is entitled to compensation. Now, Lancashire and Yorkshire Railway, one test at any rate which is applicable is the person's employment to hazard, to suffer to do, which caused his injury. This is what exactly I am telling you. This is an observation of Lord Sumner. If the answer is yes, that the injury is because of the hazard, the accident arose in the course of and out of the course of employment. And then they explain there must be some nexus, some causal connection between the accident and the death. Nexus or causal connection means, say you have a bulb and you have a switch. The moment you put on the switch, the bulb is on. So there is some connection between them. Likewise, there must be some connection between the accident as well as the cause. At torts, there is a maxim, in jure non remota causa sed proxima spectatur. That is, the law will cater only to the immediate causes and not the remote ones. So if the employment is a contributory clause to the accident of the employer, is liable to pay compensation. Now, the ambit of the above words was observed in many cases by Sikri versus Manikchowk Mills case, and then the causal connection between The onus is upon the applicant. Now, this is very funny. Normally what happens in social security legislations, compensation is act for the workman. But who is to prove that the accident arose in the course of and out of the course of employment? The onus, that is the burden of proof, is on the workman himself. And workmen, as you understand, are illiterate. Sometimes they can and sometimes they cannot. Okay. So all of these things have to be seen in a proper perspective. It is not necessary the workman must be actually working at the time of his death, or that the death must occur while he was working, or that he has ceased to work. The evidence is balanced if the evidence shows greater proportion which satisfies a reasonable amount. Now you see here there is no proving beyond reasonable doubt. You have to see the greater preponderance of probabilities in order to prove the accident. So which satisfies a reasonable amount of negligence or whatever, the work contributed to the causing of the personal injury. And here the workman is to succeed. If he does it, that yes, it is because of your work only I met with an accident, then the workman will get the compensation. Okay. But even after all the decisions, the meaning of the words is not clear. That is also another headache, which everybody is facing. Now, Supreme Court, Justice Ramaswamy's expression on in the course and out of the course of employment, the injury by accident must arise both out of and in the course of employment. I told you only at least 5,000 books are written on this. It is reasonable to believe the workman would not have suffered, but because he is in the employment. So what they say, there must be a causal relationship between the accident and the employment. Then nature, conditions, obligations, incidences, all should be seen in a proper perspective, which will make a reasonable man conclude that the accident arose because of the employment. And if at all the accident arose in the course because of the employment, then compensation becomes payable. If by reason of those factors the workman is brought within the zone of special danger, the injury would be one which arises out of the employment. Now, special danger, I'll give you another example. Do you know that there are divers? They go on ships. Deep rigs are there. And these divers have to go to the bottom of the water. The deeper you go, the water pressure is very high. Sometimes they are sent in capsules, and when they come up, they are not exposed to sunlight immediately. They are kept in quarantine, sometimes for 1 day, sometimes for 3 days, 7 days, 10 days, whatever the doctor says. And then they become acclimatized, and then they are brought slowly and slowly into the atmosphere. Otherwise, they will die. Now you see, they are already in a hazard. Or people who work in foundries, the heat is so much that gives rise to so many other diseases. Say, for example, a person who works near the foundry for 8 hours a day for years together is bound to be impotent. All these things are occupational hazards. Then, if the accident occurred on account of a risk, which is an incident of employment, the claim of compensation must succeed. Okay. And here, as I told you, case should be a proximate cause and not a remote cause under the maxim. What happened?
Hello, yes, sir.
I lost the slide. Yeah.
It's visible, sir.
Yeah. So, in jure non remota causa, said proxima spectator, the case should be a proximate cause and not a remote one. That why did the employee suffer? Because the employer did this thing, that thing, but is it having a connection with the accident? If it has, then he will get the compensation, otherwise not. Now here see some general principles. I'll be a bit fast. There must be some nexus between the injury and the accident. Burden of proof that the injury was due to the resulting strain of work is on the applicant, that is the workman. In cases of death, it is not necessary. Workman must be actually working at the time of his death. Now there are two theories which I will tell you, and then depending on the time we will close or whatever, because my time is limited and the act is like an ocean. One is a doctrine which is called as a doctrine of notional extension. I remember I was appearing on behalf of Hindustan Antibiotics. The shift begins at 7 o'clock. There was a worker who left his house at 6 o'clock in the morning. At 6:30, now you see at 6:30, he is not even entered the gate of the factory. At 6:30, in order to relieve himself, he went into some bush. And after relieving himself, there he was bit by a snake. And all the other workers who were coming, they saw him, there was froth on his mouth, they picked him up, sapne kata. So you know how it happens in India. They rushed him to the hospital. Almost at 7 o'clock, they entered the gate. By the time they entered the gate, the doctor was there. He said he is already dead. So the person died because of a snake bite. Now the point is, the company did not send a snake to bite him. Matter under the doctrine of notional extension reached the Supreme Court. Supreme Court said, why did he leave his house? Where did you want to go? You left the house because you wanted to go to the factory. Factory begins at 7 o'clock. That is the actual employment. But when you began, mentally you left your house for the factory. So notionally your employment began at 6 o'clock in the morning itself. So though you are bit at 6:30 and the shift is yet to begin and the snake is not sent by the company, yet the company will have to pay compensation. Let me tell you, friends, in fatal accidents, the court looks at all of these things in bad light. Come what may, you'll have to pay the compensation, where the defenses are very limited. So this is the doctrine of notional extension. Somebody suffers a heart attack while he is going on duty, compensation becomes payable. Somebody meets with an accident and he is hit on the road by some other vehicle, again compensation becomes payable. And next is a theory which is called as the doctrine of added peril. Peril means danger. You add to the peril means you add to the danger. That is, suppose, I'll give you a very simple example first and then I'll give you another example. Simple example is, I am a driver and I am totally drunk and I am intoxicated. There is incoherency in my speech. I cannot see properly. I cannot walk properly. I hoggle while I walk. And then I stumble. Somehow I open the door of the car. Then I start the car, put the accelerator. Car goes in full speed and I cannot understand what's going on. And I die in the accident. Question, the employer will say that it is not because of me you died, but it is because of the drink you died. So you have put, by drinking on duty, you have added to the peril. And this is the doctrine of added peril, that is, you add to the danger. If you yourself have added to the danger, why should the employer pay you compensation? Now what happened is, I'll tell you a real example. The name of the company also I will tell you. That was BK Benzil. There are some other issues which come up. BK Benzil is a company in Bhosri, MIDC, Pune. And I still remember it was Diwali day, Lakshmi Pujan. And that company, what it does is, there are huge tanks in which acid is made, concentrated acid. And that is exported to United States of America. Now, if you see on the tin, if you pour concentrated acid, so it will react with the tin. So what they do, the tin tank, from inside, they put a rubber lining. Now that rubber has to stick to that tin from inside. So what they did is, there was a mixture of gum and petrol. Then you apply that gum and petrol to the rubber and stick that rubber on the wall of the tank. So when you pour the acid does not react with the tin, but it is poured on the rubber. Now, while they were going, they met one worker. The worker said, I want some work. In India, you know how it happens. Kya kaam karega? He said, anything. Chalo hamare saath. So they took the worker. Then that contractor told him that, see, this is the rubber. This is the way you apply the gum and the petrol mixture. Go inside the tank and stick it on the wall of the tank. Tank is huge. At 12 o'clock, 1 o'clock, it was lunchtime. So all the workers came, sat beneath a tree. This new worker finished his lunch earlier. And He said, I will start work. So he went inside the tank again. That rubber lining, petrol and gum mixture, he was putting it. Then the lid was not getting fixed up properly. So that lid has to be rubbed. So there is a machine which is called as an abrasive. When you sharpen knives, I mean, you have seen those people who sharpen knives. He's got an abrasive which revolves and on which he sharpens the knives. But then there are sparks also. This worker, not knowing, he started from inside, he started using the abrasive. There were sparks, and just now I told you that the mixture is a gum and petrol mixture. Everything caught fire. Worker was inside in a jacket of fire, and he started shouting, "Bachao, bachao, bachao." Then all other workers rushed. Somehow they pulled him outside. He was taken to the hospital where they said that he is 98% burnt. For your information, friends, if a person is burnt 15%, that becomes fatal as per the Dermatological Society of America. In India, if a person is burnt 25%, that becomes a fatal case as per the Dermatological Society of India. And he is 98% burnt. And he died. At that time, his wife was pregnant. After a month or so, she delivered a baby. And a workman compensation case, I still remember, was filed on behalf of that small baby, 1 month, and his mother, that is the widow. And here the passing the parcel started. The principal employer in whose company this happened, he said, I don't know who he is not my worker. Now the contractor had not taken whatever are his attendance and this and that. Contractor also refused. He said, he is not my worker also. Whereas what had happened is they were walking towards the company and this person came and said, Kuch kaam hai kya? And the contractor said, Chalo hamare saath. Only this much had happened. Now who's to pay him compensation? Court did not say. The Panchnama showed, the police Panchnama showed that the death occurred in the on the premises of BK Benzil company. So court said BK Benzil has to pay the compensation, which was 7 or 8 lakhs. And I still remember it was a very sorry picture that the widow with her 1 month son, she used to come to the court, stand in a corner, and then a small child has his own demands and all of those things, and for workman compensation because her husband had died. And it was a very sorry picture to see. But friends, this goes on and on and on. Now, you see, this is too big an act for me to comprehend in 1 hour, which I told you. And it is already 1:01. And I would be delighted to answer your questions also. Though I tell you, this can go for the full day. But then in 1 hour, whatever is possible, we saw what is the act, how the act came into picture. We saw what happened about Interkitek. We saw as to when an employer is responsible. We saw as to what is in the course of and out of the course of employment. We saw when the compensation is to be granted, not to be granted. We saw as to what is influence of drinks and drugs. We saw as to what is doctrine of notional extension and doctrine of added peril. So all these are the major fundamentals which we have covered as far as compensation is concerned. Not to give compensation invites penal consequences also. And today a time is come, if at all there is an accident, compensation will be decided later. First, you pay the compensation in the court and deposit the compensation. Just a couple of months back, I had a matter, Diwali time. Now you see these hoardings are made for which there is a matrix of bamboos they make in front of the hoarding. That is called as a scaffold. And some painter was there. He was to paint that hoarding. He went in the market, bought those pointed shoes for Diwali. Wearing those pointed slippery shoes, he climbed that scaffold. And from there he fell down and he died. And his family members and all of them were not ready to burn the dead body unless and until they pay the compensation. My friend called me. Ultimately, I calculated the compensation, legal compensation was 4.5 lakhs, and they were asking for 20 lakhs. And money in India, once it is paid, is paid. So ultimately, we refused. And then these people were not to burn the dead body itself. So somehow we were at pains to convince them, and this and that, and ultimately we paid the remainder in court. So such things also happened. I would now stop here and 1 second. and answer your questions. Okay. I hope you have listened to me carefully. Okay.
Yes, yes, sir.
And
Thank you so much, sir. It was a wonderful and, of course, knowledgeable session as always. Yes, Ansh, over to you.
Before delivering the vote of thanks, I request the students, if you have any questions, please feel free to ask to sir. Are there any
Just one
questions?
second.
Please.
Yes, just Ansh, wait for some time. Okay.
Yeah.
Hello. Yes, students, if you have any question, kindly unmute yourself and you can ask the question now. Hello. I think they can unmute themselves. Yes, I think. Hello, any question? Hemant, Saket? Just 1 minute, Ansh. ते unmute करू शकत नाही का स्वतःला? Unmute नाही करत आहे ते direct. Yes, Ansh will go for vote of thanks.
Indeed, it was a wonderful session, sir. I, Ansh Verma, BLLB first year student, on behalf of Bharati Vidyapeeth, deemed to be University, New Law College, Pune, deem it as a great honor and privilege to propose a vote of thanks on this virtual event. First and foremost, we thank our special guest, Advocate Dr. Shrikant Maligaonkar, sir, for his time and consideration for the event. Sir, in all veracity, you have created a tornado in the pattern of our thoughts and ideologies. We once again thank you for your illuminative and magnanimous presence. We are grateful to Dr. Ujjwala Bendale ma'am, Dean and in charge principal, for her words of encouragement. Her guidance has always encouraged us. I would also like to extend my gratitude towards faculty coordinators, Dr. Jayashri Khandare and Ms. Neha Khan ma'am. Last but not least, I would like to thank all the faculty members and technical staff, Mr. Manoj Gavade and Adit Tipse sir. Thank you so much.
Thank you, Ansh. Thank you so much, sir. Thank you.
thank you. Thank you.
Thank you, one and all. Pause करें.